everybody to today's webinar. For those of you who don't know me, my name is Crystel Rynne and I am the CEO here at HRLocker. Today I am delighted to have Terence Morgan and Emer Kelly. Terence is the company director of GHR Consulting and Emer Kelly is a senior HR consulting with GHR Consulting. We've worked with GHR for a number of years, both in a professional capacity and also from a partner perspective. So we are delighted to have the team with us today. Thank you, Terence and Emer, for being with us. As we go through the presentation with Terence, the questions and answers section should be open on the chat section. So if you have any questions throughout, spoke to Terence about this already, warned him that people like to ask questions throughout. So please just throw your questions in the chat or the Q&A section and I'll pose them to Terence and Emer. If there is a more pressing question that you have in regards to something very specific to your own company, it might be about a specific employee, you can drop your details in the chat or I'll be passing on Terence and Emer's details afterwards. If you want to reach out to the guys, they'd be happy to take any specific questions as well. But throughout, if you have any questions, please drop your questions into the chat box and I'll interrupt Terence's lovely monologue to go through anything. So Terence, thank you so much for being here today, and I'm going to pass you over. Do you want to maybe give, first of all, I think through your slides you give a brief overview anyway, but yeah. I'm going to continue first of all to everybody can see you, and I'm going to share content. I think I've done the wrong thing. Brilliant, go for it, Terence.
Okay, good morning. Thank you very much, Crystel, and as always, thank you for the invitation. Long professional association with HRLocker, so it's always a pleasure to work with these guys, whether we're rolling out their service or we're on webinars or we're doing a bit of learning and development. Fantastic. So on the face of it, the first slide up there today by my lovely colleague Emer Kelly, and big thanks to Emer for actually compiling all the presentation, doing all the research, and basically just really helping me out on that side of things. So a big thanks to Emer. Her attention to detail is always fantastic. So on the face of it, you might do a bit of an eye roll when we see the first slide and go, good God, probationary periods, contracts, and record keeping. Not the sexiest part of HR, if I can use that term, but certainly the scaffolding, the foundation of what you need. All the other, I suppose, pieces of legislation that we've seen more recently since the COVID pandemic would be what I would call more, I suppose, aspirational. They're lovely, but you need to have this bit done first. Having said that, what I always look on this area of HR is it's your first impression with your new hire. It's your culture. It shows them when they come in the door that this is how you're set up, that you have a good system in place. And that's something I suppose we're all struggling, is the recruitment and retention of employees. So you really can't miss a beat on anything you're doing at the moment. But what we're hoping to give you this morning is a little bit more detail on it, the do's and the don'ts. And it's really essential that you get this first bit right. And if you have a good process set up, well, then everyone should pass through it in the same way. Okay, Emer. So on the next slide, we've got a terrible photograph at the top and a nice one of some of the team at the bottom. So just to repeat maybe what Crystel said, we are GHR Consulting. We'll be 6 years old next month, which I can't believe. We're based here in Galway City, but we service a lot of the SMEs around the island of Ireland. We do HR consultancy, we do one-offs, we do retained services, learning and development, and recruitment. So that's the selling bit on my side. But once again, as Crystel said at the outset, if anyone has a more detailed query, please drop us an email and we'd be happy to continue that conversation offline. I'm just conscious of time today and making sure people get out on time. But there's no issues if you need a question, etc. So webinars, training, learning and development. A bugbear of mine is training or webinars for the sake of webinars. What we really always want, to ensure you get something out of this morning for the time you spent with us, a tip, maybe a little bit of direction or a better way to do something. So what are we going to look at? So probationary periods. So we're going to look at them for their purpose, for their legal considerations, extensions, and best practice. So that's something that has changed recently, and we'll go through that shortly. Gain clarity on employment contracts. essential to, all right, I'll just have a pop up there. Excuse me. Getting clarity on employment contracts, essential clauses, compliance with Irish legislation, and how to tailor contracts for your business needs. A good tip here is always to have bespoke contracts. Please don't use Google. I've seen some horrific examples of a template downloaded from Google. The devil is in the detail. And then learn effective HR record keeping practices. So the team will tell you in our office, this is a question we get all the time. You know, how long should I keep contracts for? How long should I keep payroll for? You know, if I have a WRC audit, what records do I need to have? So we're going to give you some, maybe a little bit of insight into that and have a good system in place for keeping them. So that's the three main parts of this morning. So on the next slide, we're going to talk about probationary periods first and foremost. So, three questions wondering if you knew this. So, in the private sector, probation cannot be extended beyond 6 months, except in the exceptional circumstances and only if it is the benefit to the employee. And in brackets, what does that mean? So that's something that we're going to cover. This is newer legislation. And if the probation date passes without review or extension in writing, the employee is deemed to have passed probation, right, and becomes permanent. So the onus is on the manager, the business owner, to ensure they have a process in place to ensure that the probationary period is reviewed. You know what, I would even add to that, it shouldn't be up to 6 months. You should really be on the journey with them for 3 months. There should be check-ins, etc. But that's something that we will look at as well. And if it's a fixed term contract, the probationary period must be proportionate to the contract length. So that's kind of going back to what I said about contracts, but it includes probationary period. They've got to be specific. And we will look at contracts. You've got so many different types. You've got part-time, full-time, fixed term, variable hours, defined purpose, and on I go. It's always important that the contract is an accurate match and a fit for the operational side of what the employee is doing. And that would include if somebody starts on an initial contract and then moves to a different position within the organization, you want to ensure that that's updated as well. But for the first part, let's look at some of the probationary periods. So the basics, which is something we always like to instruct our clients with to start off. Why would you have a probationary period right in, I suppose, contract law in Ireland? So it's a trial period to assess suitability for the role. It's commonly 6 months, but 12 months is something that's in the public sector as well. 99% of our work is in the private sector. We don't do much with the public sector, but it is something to be aware of if anybody's on this morning. It must be clearly set out, the probation terms and including the notice period. Regular feedback meetings are essential to track performance and conduct. So that's something that I touched on before. It should never be a surprise. You know, at the end of a probationary period review, it should never be a surprise, the outcome to the, you know, I would say to either party. You know, if that is the situation, well, then you need to change what you're doing. And the employer, it's the obligation of the employer that they must confirm in writing whether the employee has passed, failed, or been extended. And Emer has included public sector only there, which we will, I suppose, touch on as well. So I hope that slide is okay for everyone. So the key legal points that you need to have, I suppose, in your locker, no pun intended, is the Unfair Dismissals Act. It usually doesn't apply until 12-month service, but claims such as equality, I suppose discrimination, whistleblowing, which is also known as penalisation, it can still arise during probation. So those employees, what you'll see on their life journey or their employment journey is they accumulate rights as they travel through the organization and as they have more of a service time. So it's just important that you're aware really of when those rights kick in. Also, the employees are entitled to a statutory minimum notice right after 13 weeks pay, even during probation. And this can be paid in lieu. So we'd often get queries on people who are being let go. So we always talking to them about make sure you pay them their holidays, right, and you give them their time in lieu. It's also important that you check your contract to see what the notice period is in that, because I've seen all kinds of notice periods over the years. And then I suppose on the best practice side of it, it's really important to keep notes of meetings, set clear expectations, right? And don't let probationary slip by without action. We're all really busy people. You probably have a million and one things to do. Make sure you have a system in place which reminds you right on probationary or reviews. It's really critical that happens. So key changes under the Transparent and Predictable Working Condition Regulations 2022, and my poor eyesight means I have to lean in. In the private sector, probationary periods cannot exceed 6 months, except in exceptional circumstances, right? And to the benefit of the employee. Once again, I'll reiterate what I said already. What does that mean? So this is something that we are watching very closely in the WRC. A lot of new legislation, evolves with precedent. The legislation is a little bit vague, in my opinion, because the way it's written, nobody's quite sure in it. But I give the same tip to all our attendees. You make sure you're not the test case in the WRC with the outcome. That's the best tip I can give for you on it, and make sure you're fair and transparent in your process. For public servants, probation may go up to 12 months as a standard under some roles. So that's not something really that we work in, too often. So I'm going to move on from it fairly quickly. I think most people on here are private sector. And for fixed term contracts, the probationary period must be proportionate to the expected duration of the contract and the nature of the work. So this is another good example of why it's got to be a bespoke contract. So for example, if you have somebody on a 2-year contract and you try to put probation in for 12 months or something like that, that's not going to work. So it's always got to be proportionate to the overall contract. So, right, as always in our, I suppose, webinars and training sessions, we like to speak a little bit about case law. If anybody needs more detail on some of the cases we've referenced, please drop us an email and we can send you the full shooting gallery on it. But once again, thanks to Emer for summarizing this. So I suppose this is a good example of an assistant lecturer who was against an IT. So the complainant held a 24-month fixed-term contract, but had a 12-month probationary clause. So the WRC found that the 12-month probation was disproportionate given the contract's duration, nature of the work, and lack of structured review performance feedback. That's a really important point. So it's disproportionate because it's a 2-year contract, and the lack of a structured review or performance feedback. So, you know what, if you recall what I said earlier, but it should never be a surprise to either party, make sure you have check-ins and you have a system in place. This is really what you should always be thinking of. I don't want to make you all too pessimistic, but the way we operate, it's always in the back of our mind. I suppose if the team are doing some consultancy work, is there a WRC gap here? Is there something we're not doing that's best practice? So that's what you should be always thinking about. So the outcome of this one was the probation was reduced to 6 months and compensation of €1,000 was awarded. What this really highlights is even when probation terms appear legal, they can still be struck down if, number one, they're not proportionate to the contract length. So if somebody's on a fixed term contract and there is no structured monitoring, feedback, or mechanism, or there's no justification, right, that's tied to the role requirements. What you'll see a lot of in the WRC is what we call objective justification. And it's something you need to be really conscious of when you're drafting documentation. Is this relevant? Is this suitable for my employee? However, it's something you should really keep in mind of, because as I said at the outset, it's probably the first interaction the employee will have with you after the letter of offer and the interview is their contract of employment, and in there is their probationary period. So you want to ensure you get that right.
I'm going to interrupt you there, Terence, because I was wondering when we get our first two questions and we have
Okay.
two for you. So it's around proportionality. So what proportionate means practically? What length of contract? 6 months. So if you have a 6-month contract, what kind of probationary period would you put in for that?
Oh, if you were giving a 6-month contract, okay, well, I wouldn't do that in the first instance. So with obviously to give a more detailed answer, I'll give a more general answer to that. If it's a contract of indefinite duration, you're not sure what the role is going to be, or if it's seasonal, your 6-month probationary period is kind of your trial period. So that would protect you. We get this all of the time. Oh, yeah, I'm only giving them a 6-month contract The only time you can do a start and an end contract really is if you're, I suppose, would be carrying out a specific role. So, for example, I give the with idea if you have a team of civil engineers and you're building 2 bridges this year and you need to hire 5 more and it's going to take 18 months, that's objective justification for a specific contract period because there's a start and an end date. However, you don't want to give them a 6 month contract, as a trial to see are they any good. You just ensure you have your probationary period right as built into your contract of employment, and that's enough.
Yeah, I think it's kind of probably an old-fashioned thing that people use
It
this
is
kind of 6-month thing where it doesn't actually mean anything because
correct.
right they still have the same protections as everybody else.
The legislation will override anything that's inaccurate.
Hmm.
So always remember that. However, a well-written contract is absolutely priceless because it's going to tie in and be compliant with legislation. What an employer will find is, from the get-go, if something isn't right, it's very hard to go back from that. You know what I
Hmm.
mean? You know what I mean? If something becomes litigious or, if the relationship in the workplace becomes fractured and you're relying on the policy or the contract of employment to stand up for you and be robust, well, that's not going to happen unless it's specific to the role. So you've got to have confidence in what you're doing. So it's a really good time to look at it.
And that's step one of like from a WRC
Oh my
perspective.
God.
Step one, show me your contract.
Oh my God. It is like
Yeah.
anyone that knows me and has gone to my events over the years, their ears will be bleeding for me talking about your contracts because we do, all kinds of events and we talk about societal change and working from home and flexible hours. But then you go and talk to somebody and they tell me they don't have a contract of employment in place.
Step one.
This is, yeah. Okay. So that's the part I'm always on about. Please do this first, and then we can look at everything else.
So I think kind of the two questions are quite similar, and maybe
Okay.
we might kind of the other two, there's two more that we might kind of take them offline. But if there's a fixed term contract is for 1 year, so let's presume it's for a very specific task, can the probation period be for 6 months? And in that probation
No.
period, there's a 1 month, 3 month, 5 months.
So I suppose we referred to this earlier as proportionate to the length of the contract. So that's what I would be looking at. But then I would also be asking, why are you issuing 6 month contracts fixed term? And how many of those have you issued to the employee? Because after you issue, I think it's 4 off the top of my head, Emer, would it be right? Um, you have to change it to a contract of indefinite duration. You can't just keep reissuing 6 month contracts indefinitely. You know what I mean? If there's continuous service. However, as I said earlier, if you're building a bridge or something with a start and an end date, that's different. However, if that person wants to pop us an email and we
Yeah.
get some more detail on it, we can give a more detailed answer. They're very generic answers because I don't have all the detail.
Yeah, and I think there's a number of questions around that kind of fixed term. Um,
Yeah.
and like we have a maternity leave contract, which is a 6 month duration. So
Yes.
I'm there to cover the maternity. So like,
So proportionate again, I would say, but it doesn't set out in legislation, um, it's not specific. It doesn't say if you have 6 months, you have to have 1 month. If you have 2 years, you have to have 3 months. You know what? It's got to be proportionate, but we can certainly give some direction on that. I'm just thinking off the top of my head, what might be a good idea, Emer, is to look at all the different contracts and we might do a sheet of what we would recommend as a probationary period for each of them, and that'll answer all the questions.
we can share that with. And I think as well, Terence, would you agree that like say with probation, I think sometimes people really get fixated on, focus on extending it, but
That's right.
you should kind of know in month one, month two, month three
That's
of
my
where you're
point.
going, right?
Yeah. And as I was talking to you offline before, and we've launched, I suppose, manager training, and this is one of the areas that we cover is the style of management. There's got to be check-ins. The employee and the employer should always be aware along the journey. And as I said, really nowadays, in my opinion, everything goes back to retention of staff. And the employee nowadays are looking for feedback, who want to grow their career, who want correction on what they're doing. So it's really important as a manager that you know that and you check in with them. So when you get to a review or a probation, it's just a formality
Yeah.
rather than. Now, I know somebody quite well who went to their probation. I shouldn't be laughing because I know them very well. Who went to their probationary period. thought they were doing a great job and left it in no uncertain terms that they weren't. And it was a complete shock to them. And this was quite a senior position. And I couldn't believe that. But just lack of communication is a killer for everybody. So
Exactly.
just have a simple system. And it doesn't have to be formal all of the time. I mean, 2 minutes chat in the morning. Now, you need to record them at certain junctures if you have a 3-month review. But however, the informal check-in, is something we always like with our team. And it gives you a good idea, of where this employee is going. So yes, have the formality to support it, but also have the style to ensure you're never caught on,
I mean, that's it. Nobody should be sitting there at 6 months. And I know there was a lot of
excuse me.
no extension probation.
That's right.
But the key is that like nobody should be completely surprised at 6 months that they didn't work out.
Yeah. And you know what? If it was a year and a half ago, or for the last 20 years, if somebody rang me and said, right, I have a lad working for me there, and it's usually on the hands-free on Friday evening at 5 o'clock, and he's coming up to his 6-month probation and I'm not too sure about him, I would have just automatically said to them, you know what, extend him for another 3 months and see how you go. That's not the guidance we give now. We're very strong on this now. You've got to make a decision on it. However, please don't ring me when you say, yeah, he's 5 months and 3 weeks into his probationary period. Please do it before that. So these are the ones. So that's the.
Fix it for me, Terence. Fix it.
Yeah. Oh, well, look, I mean, it's as simple as that. But guys, do have a system. Please keep the check-ins. Also keep your notes for the official reviews. However, my manager advice would be you should always know where your team are at, who's struggling, who's performing. And as you know, I'm sure a lot of you here manage people. It's not the professional side of it. It's more personal often. It's families, it's lateness, it's issues. That's what you have to deal with when you're a manager. So 100%, that's the way to go.
I'm going to do 2 quick questions, then we're going to move on. And again, this is around those fixed term contracts and then moving on to a full term. So let's again presume that the fixed term contract was a specific reason. Now they've moved them onto a full-time contract.
Yeah.
They require another probationary period.
No, you can't start. So with continuous service like that, if they had, okay, so say they join on a year's fixed term contract and then they come up to 12 months and then they've done a great job and the business says, yeah, we're going to make you permanent. They've already completed their initial probationary period on their initial contract. You can't start a new 6-month or 3-month probationary period with the second contract. So the answer to that is no.
And then the last one then is, what about in terms of, does the notice period of employee count within the probation period? So example,
yes, I think
2 weeks.
Miss Kelly has preempted all these questions with her presentation. Over there, she had covered that. So I think we're going to come up to that, Emer, from memory on it.
I'll mute myself and let you keep going.
Yeah, okay. No, that's fine. I often find myself doing this, that I go through presentations, answer all the questions, and then I come on and the team have already, got ahead of me. Sorry, there's one more has come in there, I think, Crystel, before we move on.
What if they've changed roles? Can we put in new probation?
No. And I would also add, you would need to put in what you call a contract amendment. So if somebody is moving position, manager, or they're moving sideways or whatever, make sure you do. You don't need to issue a new contract of employment, but you should issue a contract amendments.
Yeah, perfect.
Okay. So some of the questions that I think some of the delegates are asking, and Emer has kind of preempted them. So can a new probation period be applied for a renewed fixed term contract? No is the answer there. If the renewal is for the same role and tasks, a new probationary period is not allowed. And that's something we touched on. Second question, can I employ someone on a trial contract and then offer them a permanent contract? So once again, Emer said no, which I agree. There is no such thing as a separate trial contract under Irish law. Instead, you should offer a standard employment contract with the probationary period. This is something actually you still see a lot of in hospitality, and it's a small bit of a tangent, but it's relevant. We get a lot of queries with hospitality clients who use trials. So they'll take in the college students or whatever, ask them to do a day's trial and then give them the job, but some of them aren't getting paid. So we've been quite strong on this, saying you're leaving yourself open to a WRC claim. You've got to pay them for all the hours that they've worked or leave they've accumulated. There is no such thing as a trial basis, or if there is, I haven't seen it. So don't do that, would be the simple advice we would give to all our clients on it. So if an employee is changing roles, Can we start new probationary periods? Once again, Emer is preempted. No, an employee cannot be put on a new probationary simply because they're moving a new role. The permanent contract still applies, and you may treat the new role as a trial or assessment period, but termination cannot occur simply because they don't work out in the new role. And that's a really good point. What you're probably looking at there would be performance management if it wasn't working out in a PIP, and on we go on to that. And then finally, on the other question, it says, can I extend an employee's probationary period if they've missed time? So the answer is simply yes, but carefully. I like that slide, Emer. It's a bit like Father Ted. Yes, but carefully.
Careful
So
now.
yeah. So probation can be extended to make up for lost time, especially if the employee was away for parental leave, sick leave, or other approved absences, so that you can fairly assess performance. So really any kind of protected leave or sickness, you got to take note of it and you got to extend it at the other end. So any extension, like a lot of things, it must be documented in writing before the original probation end date. So that's a really, really good point. Once again, it's going to come down to your notes, to your documentation, really, and your written communication. Please don't do, I suppose one of the things I should have said is, please don't do any of this just verbally.
Mm.
It's fine with the check-ins and the daily and the weekly huddles or whatever you hold with your team. But for any specific milestone reviews, etc., make sure you document it, because that may be what you have to fall back on 6 months or a year down the line.
Yeah, there's actually a question here saying,
Go
what if
ahead.
what if there aren't any check-ins, and you have a problem?
Then you need to look at your system.
Mm.
There should be check-ins. If it's something that is within your role to manage your team, and part of that is performance, output, retention, morale, culture, etc., your management system should have a process for performance review. It's critical, guys. It's really, really important. I mean, if you think about it in a sporting context, which is a big thing that we do, it's like training a football team for, you know, the county final in 6 months' time, but not really talking to any of them or having any training and expecting them to turn up on the day and, you know, like win the game. It's
Mm.
not going to happen. You need the structure there. You really, really need the structure and the check-ins. So you can amend it. I've often seen maybe employees where you thought they mightn't make it, but really good coaching, mentoring, you know, it turned out there was another issue that they didn't disclose, or there was something else going on that was affecting their performance that you're never going to find out about unless you have a good relationship. Anyway, we always like to do our takeaways in GHR. So training for the sake of training, as I said, is not something we do. So I would love if you guys took this away from today. So the duration limits, private sector, max 6 months. Please keep that firmly ensconced in your head. You cannot extend unless they're out sick or unless there is something that's in the exceptional interest of the employee. So it's not for your benefit. Please remember that. The only time you can possibly extend is for the employee's benefit. So the extensions must be justified, only valid for exceptional circumstances, and must be to the benefit of the employee. It's pretty much what I said. Fixed term and role changes at probation must be proportionate to contract length and cannot start a new probation for the same or similar role, a question we had earlier. And rights during probation, employees are still protected from discrimination, breaches of contract, and penalisation. And I'm going to throw a curveball in here as well. Something we've seen a little bit of a rise on is the Industrial Relations Act 1969. So most people are aware that you can't take an unfair dismissal claim until 12 months service has been completed. But there is another little piece of legislation in there, as I said, called the Industrial Relations Act 1969. Now, any award on this is not enforceable. However, because the WRC isn't anonymized anymore, what you will actually see is a lot of headlines in papers. And this is public knowledge, so I'm not breaching anything. There was a fairly big case there a number of years ago with quite a famous hotel down in Kerry, owned by two brothers who might make some TV appearances. Uh, and their manager took a case under that piece of legislation, even he was less than 12 months. He won, and it was all over the paper, but the payout wasn't enforceable. But I'm sure the negative PR side of it was not something the company I wanted. So just keep an eye out. It's not very common. However, it is something that we've seen a little bit more of.
And I'd agree with you. It's actually it's the reputational damage of a company.
Oh my God, yeah, it's absolutely huge. So they're the key takeaways for the probation guys. Really, what I would say to you to summarize it all is you can't extend probation anymore unless the employee, right, has very strong reasons or needs, illness, or they're out, on protected leave. The other thing I would say to you about probation is please don't let it run to 5 months and 3 weeks. Try to do a 3 month official check-in, but also I'd be looking at having a chat. I make sure you have the open door policy with your employees. It's so difficult to find good employees. It's such a cost to train them up. You want to do everything you can to retain them. And I look on this nowadays as another form of staff retention. If you have a good order, if you have a good system, really good onboarding, and everyone makes the same journey through the business when they start, it's really, really critical.
There's 3 or 4 questions. I'm just going to do
Yeah.
one. Move on then from that is just conscious of time. There's a number of questions in regards to if they've had a significant role change
Okay.
in that.
You could issue a new contract of employment, but their service will and their leave, etc., unless this is all renegotiated, which I should have said. So literally with a contract of employment, it's a bilateral agreement. You can't change it unless there's agreement by both parties. It's pretty easy to change it if you're promoting somebody or you're giving them a pay rise. The other issues will be the other way. So for a significant role change, I would issue a new contract of employment. But once again, I need to see the detail of what the old was, what's the new job, etc., etc. But 100%. But don't think by issuing a new contract of employment that they're on day one.
Yes.
Okay, they're not. It's
Yeah.
just a role change. So they're
Move
continuous
them
service.
back to their old job.
Say again, Crystal?
Move them back to their old job during that time, because that's the probation.
Yeah. I mean, everything is up. Yeah, yeah.
Perfect.
I'm just going to jump in really quickly. We actually touch on it in the next few slides,
Okay.
but what we'd always
Way ahead of us.
advise is a contract amendment letter. And when there's a change like that,
That's right.
you'd say, okay, this role is going to be on a 6-month or a 12-month trial basis. And if things don't work out, you return to your original role, and that there's a signed agreement in place. It's just the probation. You wouldn't be allowed to terminate them if they
Yeah.
weren't working out in that more
Yeah.
senior role.
Okay, so that's a really good point because it's trial, but you can't, I suppose, terminate them because of that, because it's not specifically a new probationary period. However, it is a trial for the new role. So it's similar, but not the same.
Yeah.
So I hope that's clear. However, we can clarify it for you. So once again, it's like a lot of HR queries we get. We'd need to see the original contract that they're on. We'd need to see the new position that they're moving to, and then we can give guidance and advice. We're happy to do that.
Perfect.
So part 2 is the old chestnut of contracts and the terms and conditions of employment. My favorite subject. All kinds of stories over the years with contracts being lost. I saw a contract in Roscommon once, I think it was 60 pages long. It was written by the manager who was out sick. The business owner called me, and the contract for the manager, which he drafted for himself, said he was entitled to 6 months sick pay, full pay for the first 6 months, and half pay for the second 6 months. And the business owner was raging. And I said, "Who wrote this?" And he said, "He wrote it himself." Well, I said, "What do you expect?" And he said, "Can you not?" I said, "You can't do anything about it. That's the agreement. It's signed by you and it's written." So please, please, please make sure your contract is accurate, bespoke, and it'll work for you if you need it. So why do contracts matter? It provides clarity on rights and responsibilities for both employer and employee. It legally protects the company in disputes or misunderstandings. Established expectation on hours, pay, holidays, and notice periods, and supports a professional onboarding process and improves employee confidence. So no matter what query comes into our hotline to the team there in town, the first thing they will always say to you is, "What does it say in your contract?" That is always the question that we ask, because that's what we have to work on. And then it can be a written contract. It can be a contract created by precedent. It could be, I've seen them written on all kinds of documents. It's worth investing into a really robust, well-written contract of employment, because that may what save you down the line if there was a dispute or a claim or a disagreement. So under the Terms of Employment Act, employers must provide core terms of employment in writing, and which you'll see down the line, there's been a few minor changes to that. It must include your job title, your duties, your start date, your place of work, your pay, hours, holiday entitlements, and notice period, and pension if applicable. And I suppose, as you know, with auto enrollment finally coming down the line next year after 20 years of them talking about it, that's going to be something that's changed as well. But we have people we work with on that. So on the legal requirements, it applies to all employees, including part-time and fixed-term, especially here in our parts of the world, in the west of Ireland. We're quite, I suppose in Galway specifically, we see a lot of tourism. I'm still asked, they're only part-time, they don't need a contract, do they? Yes, they do. It's really important that you have a written agreement in place, and it helps prevents complaints, I suppose, to the WRC. So they're the reasons that you would do it. It's not just because it's a good idea, you are required. So some really good detail for you here on that. So what should be in it is another question that we always get. So the place of work and the address, and this is something that kicked up so much of a storm after the COVID pandemic, where people were working from home or working remotely. The business owner wanted some of them to come back, either part-time or full-time. They either had no contract in place or they had a contract that didn't state their place of work. Now, that might sound really ridiculous, but that was a fact. So once again, I'm going back to it. Your documentation has got to be robust, well-written, and relevant. Number two, it's the title of the job or the nature of the work, so what they're going to be doing, the start date on the employment, the pay intervals, whether they're paid weekly or monthly. We see a lot of them come in with a year's salary, the overall figure. That's not best practice. You need to pay. You need to make sure it's compliant with their pay frequency. It also includes any terms or conditions relating to hours of work, including overtime, which I'm sure will be a question. Sick pay, obviously we've had changes in that, so it's important that that's relevant. Also with pensions, and we have upcoming changes there. The notice period to be given to the employer and the employee. Details of any collective agreements that may affect the terms of employment, kind of straying into public sector there, and paid leave other than sick leave, including annual leave, and public holiday entitlement, which is another query we always get. Someone's out sick, so are they accruing annual leave? Are they accruing public holidays? Yes, they are. So what must be provided and when? So I suppose if you keep this in your head, you've done your interviews, you have identified your candidates, you've sent your letters of offer, and you've had 2 acceptances. Where do you go from there? So you've got the new employee coming in, they're all ready to go. It's really important that everything is recorded accurately and rolled out in an efficient and in a timely manner. So on the day 5 statement, between 1 and 5, it must include the full name of the employer and the employee, the employer's address, the expected duration of the contract, once again coming back to bespoke contracts, the rate or method of pay calculation, and the hours of work. So they are the 5 points that have to be included and offered and made available in days 1 to 5. I think Emer might have put some best practice in how the guys do it in the office. It's a little bit different to mine. Right, I like to put these, and you don't have to do this. Right, I like to put these in the letter of offer, because you can put in a document and it'll cover you for the day 1 to 5 for the 5 terms. It's difficult to remember everything, as I said earlier. You know, I have to get this done by day 5, I have to get this done by day 30. So that's another way. But everyone has their own system. But just make sure you have a system that's compliant and it's the same for everyone. Okay. So obviously, the other thing that I spoke to you about at the outset is, you know, as the employee starts their journey through employment, they accumulate rights. Okay. And this is another example. So within 1 month, the employee, right, is entitled to the job title or nature of the work, the commencement date of the employment, the place of work, paid leave holiday entitlements, sick pay entitlements, if any, notice period, pension schemes, and reference to your disciplinary and your grievance procedures, which are mandatory. Now, we can talk about handbooks at a later date, so I would be putting a reference to them in there. And then I would be putting them, the more I suppose, detailed process, right, and policy. Okay. It's all fairly straightforward stuff in this, but it's important that it's done right. So we've a little example here. So the offer letter, the feature of it, and the contract of employment. So the purpose of the offer letter is to confirm role and basic pay, which is the core terms, and the contract really kind of fattens that out, if you will, and it gives all the other terms and conditions of the employment. The legal requirement, the offer letter is not required by legislation, so you don't have to do that. However, the contract of employment really is required, so there's no way around that. So you can make a verbal offer, and that's fine. However, you would need to offer a full contract of employment, as we stated recently. And then on the timing of it, or just have a pop up there. So the letter offer should be sent before starting, obviously, which is kind of common sense. And then the contract of employment, as we said earlier, your 5 core terms within 5 days, and then all your detail within 1 month. Sending the full contract before day one ensures your company is legally protected. So this is the way the team do it in the office, which is really, I suppose, ahead of the curve. It's above best practice, but they're so busy, it's easy for them to have one project on the go and get the contracts done, before starting. So there's no scrambling on it. However, whatever system works for you, once it's in line with legislation, I've no issue with it. But the key here is make sure you have a system and make sure it's the same for everyone. Okay, so my favorite part of contracts, and the biggest waste of time, is trying to get contracts signed by the employee. He left it in the van, the dog ate it, I lost it, I'll get it back to you next week. Oh yeah, I will, but I have questions. People get so stressed about unsigned contracts. They're like, what if the WRC come and they're not signed? So let's take some of that stress away from you today and make it a little bit easier if we possibly can. So yes, you have to have a contract of employment in place, and yes, you have to offer and make available. So contracts can be issued by email or in person. I would add there, maybe put a read receipt on the email to ensure that they got it and have read it, or have a sign-in sheet, to a weekly huddle or a morning weekly meeting, whatever you do, so you can prove that they were offered and made available. Always attach as a PDF or Word doc for easy storage, and paper copies are optional but not required. So obviously with you guys, HRLocker, you have a facility there with offering the contract of employment. We still see some paper contracts, and I still see some lever arch files when I walk into an office. And I do take that as a tip to talk to them about HRLocker, because I might ask them, why are you still using lever arch files when you can have a digital, fantastic Irish-owned company? So
Well
it's something
done.
I encourage people, yeah. So on signatures, right, an employee does not have to sign the contract for it to be legally binding. So this is usually the part that surprises people. What matters was that it was issued and received, which is bang on the money. And the signature is acknowledgement, but proof of receipt is more important. So remember when I said earlier that we can always think, should this end up in the WRC or the Labour Court, where do we stand? So if you look at that legislation in detail, it states you must offer and make available a signed agreement. And that's the sentence that confuses people. It has to be signed by a manager or a company director or an owner. It's then offered and made available to the employee, whether that's via a digital service or hard copy, soft copy, whatever you want to give them. What you need to keep in your mind is there a way I can prove that this was done should there be a dispute down the line? Because the most common thing we will see from a claimant in a WRC case is they'll say, I never saw that contract before in my life. I don't know what that is, etc. You have to ensure that you have some proof that you offered it and you made it available. So proof of delivery, you need to keep a paper trail or an email with a read receipt, as I said earlier, an employee confirmation email, which is like confirm receipt, which is a good one, or record on a HR system or a personnel file. So best practice would dictate you issue the contract before start date where possible, which is the team do. You confirm receipt in writing, as we mentioned already, and you retain a copy in HR records to really protect the business. It is the number one thing I would say that you need to get done. Whatever about everything else, please ensure you've offered an accurate contract of employment and you have some way of proving that you did this. Don't waste any more time about getting it signed. If those two things are in place, well, then we're happy enough to move on to the next phase. Okay? Some really good questions from the contract side of it. So the signature is not essential, as I said already. A contract is enforceable once issued, and what matters is proof the employee received it. I remember I used to work with a lecturer up in the ATU at Tom. I'm a bit of an old school guy, but he was really, really good. He used to talk about contracts, you know, being in place if there was an offering and an acceptance, and that technically is true. But for HR, it needs to be in writing. You know, the overarching contract law will state if there's an offering and an acceptance, well, a contract has been formed. But if you look at it from an employer's point of view, you're depending on this piece of information, you know, if there's a dispute over pay or whatever. So please ensure you issue and make available a written contract. So the core terms on the deadline, on the core terms, which the employer must issue the 5-day statement within 5 days. So that's a change in legislation more recently. You used to have up to 30 days in the old system. The full terms deadline, so the full written statement of employment terms must be provided in 1 month. So that's the way it used to be, but they amended it with the day 5 statement. And short-term staff are covered too. Even employees on temporary, part-time, fixed-term contracts must receive written terms. So casual labour, I see it a lot in rural Ireland where there might be smaller villages with pubs and restaurants. You know, you have kids away in college. I might talk to them and they say, oh yes, they only work Saturday night. They need to have a written agreement. Because as I state to them, you know, if there's a dispute or if she claims that she was entitled to X, Y, and Z, show me how you're going to prove that. And unless it's in writing, forget it. Because it's not a level playing field. All of the legislation in Ireland, right, is written for employees. It talks about the rights and entitlements of the employees, and it talks about the obligations of the employer. So they're the two parts that you always have to be conscious of. Okay. So the Workplace Relations Commission enforcement and fines. I suppose a little thing on the WRC. So this changed back in 2015. We used to have multiples. We had the LRC with the Employment Appeals Tribunal, and they kind of brought it into two bodies, the Labour Court and the WRC, which essentially is the compliance tool for employers in Ireland to ensure that employees' rights aren't being infringed, they're getting break times, contracts, etc. What I would say to you about the WRC, I think their tagline is, you know, helping compliance with employers. It can be quite subjective with the inspectors. We have some very good ones here in the west of Ireland who really work with our clients, you know, but what I would say to you is don't freak out if you get a notification, okay? So with the WRC, you can get written notification. They can turn up on your doorstep. They're legally entitled to enter the building, interview 3 employees. I always liken it to the NCT. So I would let it happen. What they'll do is issue non-conformances, right? And then you need to tidy it up. So it's like bringing the car up to the NCT. They're probably going to find something wrong because they need to justify their existence. However, please be 100%, you know, on board that you will fix whatever they give you and you won't have an issue. It's where you go the other way, that's when you will have an issue. So having said that, it's always good to be aware of what they do, okay? So the role of the WRC is to ensure employers comply with the Terms of Employment and Information Acts. It investigates complaints from employees where terms are not issued on time, and it can inspect company records during compliance checks. So it's quite easy to go onto the WRC website and you know, take a claim. I know some of the statistics that they produce, they're really, really active. And as I said earlier, they can do it by geographical location, they can do it by industry, they can do it on the back of a complaint, they can legally turn up and, you know, like inspect some of your documentation. So on the common triggers for WRC cases, no contract issued at all, which is quite common. So that's 4 weeks pay. for non-issue of terms and conditions. The core terms are day 5 statement not given within 5 days. So that's a newer piece of legislation that people need to be aware of. Full terms not issued within 1 month, and missing mandatory information in the contract. So one of the 5 core terms that need to go in there, you can't deviate from them. So what happens if you don't comply? So the employees can lodge a complaint with the WRC, and if upheld, the WRC can order the employer to provide proper written terms, award compensation to the employee up to 4 weeks' pay, as I said already, and apply fines for non-compliance, often starting from €1,000 plus. So for a small little, mistake or something you might regard as small, it's really important that you get this bit done. And why is it important for employers? Because the journey seems to be all for the employee. Well, non-compliance can lead to financial cost, which is a massive thing. You can have damage to the employer reputation. That is something that we see a lot of now when in, I suppose, recruitment, when candidates are looking at companies. It's nearly gone full circle where they're, or even half circle, that they're interviewing the employer rather than the other way around. You need to make sure, that you have a good compliant company, and that will allow you for a better, recruitment. And I suppose a bit like revenue, once you're on the list, you may not get off the list. So make sure you're good and compliant, and they'll know, well, this guy's doing it, so there's no point coming here anymore. Whereas if they're finding non-compliances every time they come, well, you will remain on the list, is what I would say to you. Stay off the radar is basically what I'm trying to say to you. And the only way to do that is really stick with your compliance. Okay?
Perfect. Well, I do some really, really quick
shoot
them all together. So there's quite a few questions in regards to people who have old contracts who were signed like 5 or 10 years ago.
Yeah.
Do we care?
So you can, so there's no issue amending once it's a bilateral agreement.
No, they're just not signed.
Oh, my apologies. Okay, so first question, is there any proof of them receiving it? Is the most important question. And number 2, right, if there isn't any proof of it and they're older, what I would be using is to say, we've looked at all our paperwork, it's really outdated, huge amount of legislation has changed, we're going to update everybody to reflect current legislation and reissue.
Okay, perfect.
So that's another way of getting it signed. However, you're doing it under the guise of update. So that's a good reason to do it. That's something we can help with if people want to do it, or they can send in one of their old contracts as a sample. I'm sure Emer of one of her team there will have a look at it for them.
Perfect. And actually that links in with one to say that we're looking to update older contracts with updated legislation to include all the addendums that would have been added over the years. Is it okay to issue a full contract to the employee again? And Terence, I'm going to put that with the caveat to say, yes, but it has to be communicated properly, right? Like people can't be like, why are you issuing me a new contract?
100%, because we all know the one thing employees hate the longer they're there is change. Why are you doing this? You know what, sure, isn't everything great? Why are you changing everything? So we're going back to what we said at the outset about communication, right? You know what, openness and transparency. So 100%, I suppose, to want to have a better sentence, I'd be selling it to the employees to say, huge amount of legislative change in the last 5 or 6 years. It's all for employees, with parental leave, with working from home, with flexibility, with carers leave. We need to reflect that to make sure that you guys are fully up to date on everything you're entitled to. Yeah. It's really easy. I don't know any employee that would say, no, I don't want, my new entitlements put in. But please be aware it's a bilateral agreement. But I would add to that, and it's not really something we have touched on today. So I'm going to have a guess here. If those contracts are 10 years older or more, they're probably quite big. They're probably just the contract of employment on its own. The staff handbook is where most of your policies and procedures should go. And just, I know we're going on a tangent and I'm conscious of time. It's really important that your contract of employment, as I said, is bespoke for the individual, but all your policies and procedures go into your handbook. And there's a reason for that. You can only amend the contract of employment by a bilateral agreement, so you need a signature. However, should you have an operational HR manual, you can make changes in that by memoing the changes. So the best example I can give you is, right, so I have 2 adult kids that work in hospitality as they go through, I suppose, college. Both of them are always stuck to their phones. So I always ask them where they're working. Well, one of them is a client of ours, so I know they do. The other one, you know, like, have they a mobile phone policy? And they do, and they're not happy about it because it's zero tolerance, right, while you're waitering on the floor. And you can introduce that next Monday morning by really memoing that out and say it'll be effective as of, you know, 10 a.m. on Wednesday. We're going to zero tolerance mobile phone. There's, you know, a landline for emergencies, or you can contact your manager, right? And you can bring that in. Whereas if you had to do it the old school way, you'd have to get you know, an agreement from everyone in their contract that you're bringing in mobile phone use. The handbook is really important. And it's really important. It's bespoke and it has a flow, and it starts with probationary period and it ends with either people retiring, leaving, right, or being, and it covers the operational things. So you've got your CCTV, you've got your tipping policy, you've got your driving for work, you've got your annual leave, you've got your flexibility and mobility. I could keep going.
Yeah.
But you know what? But it fits for you. So a very long-winded answer, but I hope that made sense to your initial question, Crystel.
Yes, and then I'm going to answer these three questions.
Okay.
Is that I have staff who do not have contracts and are here for 15 years. They won't sign what you just suggest. My answer is going to be to contact you directly to talk to you.
Yeah. No problem. We deal with that every day of the week. So yeah, absolutely no problem. That's easily remedied.
And then I'm new to the organization that hasn't had a HR department for 5 years. So although there's contracts issued, I don't have any proof that people received the contracts. And how do I bring these up to standard? I'm going to say to contact you guys directly to talk to you how to do that. This is a strange question because I've never heard this before. Is there a requirement to update contracts every 2 years? No.
Not that I'm aware of. You should, I suppose best practice would dictate you should keep them in line with legislation, but as far as I'm aware, there's no set period of time that you must do it.
And then I actually would have an idea of who this company is. Is a HR company reached out to us recently, just a random sales pitch. I'm sure it wasn't GHR.
No.
But they mentioned targeted inspections are on the rise from the WRC.
Oh, I know who that is too.
Should I be worried about this?
No. Okay, so there's one particular company which shall remain nameless. That is their style of selling is scaring, and you were right, that wasn't us. We've never made a cold call in 6 years. We've never rang anyone who either didn't wasn't referred to us, who wasn't at an event, or who wasn't on a webinar. So don't fall to scaremongering. That should have your antenna up. Yes, inspections are about, but no is the answer.
Yeah.
It tends to be after a WRC complaint has been made by an employee. We've seen it with our clients.
Excellent.
Someone takes the case and then they go and inspect it. Or else with newer businesses, there might be random inspections. But
really good.
That,
yeah, exactly. Look, you know what? People get so stressed about WRC inspections. I mean, some of the calls we get to our office when they get the letter. So we just tell them to take a breath, be absolutely fine. We look after you. The workplace relations are there to promote compliance. The only time they will start to punish you or become punitive is if you're going the other way. Whereas if you're open to compliance, you know, having a good company, nothing to be worried about, but just make sure you do it right. And don't bow to people trying to scare you into do it. And you know what? I could have come on here today and said, you know what, unfair dismissals is up to 2 years' salary. So that's 100 grand for someone on 50 grand. Whistleblowers legislation is up to 5 years' salary. So that's 250,000 for somebody on 250 grand. All these are written in legislation, but there's so many mitigating circumstances before an award is ever paid out. So these are like sensational headlines. So don't fall to them. And you know what? Take a breath and just make sure you use any of the really Irish, well-run HR companies here in Ireland. We have some great people, really, really, really good people who can assist.
I would 100% agree with you. Okay.
Okay. So very quickly, a worker and a health service provider. Once again, this is a summarized version. So the complainant, a worker employed by a health service provider, the allegation was the employer did not provide a written contract of employment, which is a legal requirement under employment law. The WRC decision, the WRC found in favour of the complainant, highlighting the employer's failure to provide a written contract, and as a result, the employer was ordered to pay 4 grand in compensation. Now, without seeing the detail, that could be the employee did get a contract and the employer can't prove it, or it could be that the employer just didn't bother. So it's one of the two, neither are right. So coming back to that query you had earlier, Crystal, with the person who has issued contracts, and they have no proof they got them, you need to amend that. But you can contact us. You can contact us even directly, and we'll give you some tips on that. Okay. Okay. So our lovely clients, which I know Emer based a lot of her presentation on this morning because we just used their queries to build the event. So when must I give an employee their written terms of employment? So core terms on the day, so that's the 5 points before 5 days, must be given within 5 days of stating full terms within a month. So they're the two important points in that one. Does an employee need to sign their contract for it to be valid? I'm sure you've sick of me hearing saying this. No, matters the contract is issued and received, and keep proof of your delivery of your records. That's a sign-in sheet, a read receipt, HRLocker system, anything you can show, yes, it was delivered and received. What happens if I don't provide the contract on time? So the employee can complain to the WRC, which can order the contract to be issued, award compensation, or impose fines. That being said, it's always better to provide the contract late than never. Very good point, Emer. This is the query I get all the time. So I have Seamus working me there for 25 years. I never give him a contract. And then I said, well, you can introduce one now. And they're terrified it's going to be, 25 years of a fine. It's not. You can be very open with a WRC inspector to say, look, I had a HR company come in recently. I only issued his contract there last week. However, there's no fine retrospectively for that. But remember this, you have to put his original start date on it. You can't put the 1st of March this year when you give him the contract. It's the 25 years ago date that needs to go on it. So the option here is it's never too late to issue the contract. Sometimes people get scared of this and say, well, it's so long now that I haven't done it. I'm not going to do it because you know what, I might be. It's never too late. It's never too late to issue it. And remember, what you're only doing is you're agreeing and writing what you verbally agreed for 25 years. That's all you're doing. Really keep it simple. Rate pay, hours of work, etc. And do I need to issue a new contract every time a detail changes? This is something we covered earlier. So a contract addendum letter is sufficient. When terms change for an employee, working hours, always add a line in the letter that says it will be reviewed after 6 to 12 months, which gives the company flexibility. That's a really good point by Emer. It's a little kind of tangent on the probationary period, but it's a trial period for a new position within the business, not a probationary period within the company, if that makes sense. Okay. So the common mistakes. People are busy and they miss the 1 month, I suppose, time to issue the full terms. Relying solely on verbal agreements. No, please don't do that. He said, she said, I thought you meant I was entitled to 50 euro a kilometer. It's just a mess. Please have it in writing. Using a letter of offer instead of a full written contract. It won't have the terms and conditions in there. Not keeping proof of delivery or employee acknowledgement. That's so important. And omitting legally required core terms. So you can't pick and choose which ones you put in. Right. There's rules there for a reason. Please try to follow them. Okay, so the takeaways on the contract: core terms within 5 days and full written within a month. Proof that there was offered and made available is really, really important. You can document any significant changes, such as pay or roles update in writing, and later missing contracts can lead to WRC complaints, fines, compensation, and reputational damage. Okay. So is that okay? I hope that section is okay for everyone. Now, my favorite part is the HR record keeping. Between holiday pay and record keeping, I usually have to be honest, I usually get the team to ring them because my head will explode, but I'll do my best on this here. So, right, but we have Emer there too.
I thought you were going to just have one slide here to say, put it in HRLocker and you'd be grand.
There you go. I was just about to come to it.
Done now.
That's all you need to do. And it'll keep you compliant and you don't need to have the headache. So once again, another obligation on, I suppose, employers and managers is record keeping. So it ensures compliance with employment law and regulations. It supports fair and transparent HR processes, which is critical, protects the organization in disputes or audits, and it improves HR efficiency and organizational memory. So document, document, document. Some really good examples here of what, why, and where you should have. So legal records. So the employees, I suppose, personal details, name, address, right, and your public service number, your contracts of employment and job description, payroll, tax, and social insurance records, and records of your disciplinary actions and your grievance. So working time records hours, leaves, and breaks, which is, very good point, a WRC inspection favorite. They will always look at this. They will always look at your statutory break times. It's an easy one for them to get a non-compliance on. And I have to be fair, you know what, it can be a pain for employers to have to go through this. But unfortunately, we don't make the legislation, we just advise on it. So that's what's there. So that's what we have to roll with. So retention periods, really nice little sheet on this. So with payroll and tax, it's up to 6 years, not an area that I get involved in. The employment contracts, up to 3 years. Recruitment and interview notes is 1 year, so that's important. We had a serious round of interviews there recently for quite a senior position with one of our clients. One of the candidates didn't get the job, and she requested to see her, what we called her interview rating matrix. So how we scored. So it's really important you keep your documentation on that. And then obviously on your disciplinary records, you need to keep them until they expire. So that's just some simple tips on it. Okay. So organizing HR records. So this is Crystel's slide that she put in when we weren't looking. She said HRLocker should digitize where possible for easier retrieval and security. It really is the way to go, guys. I said, I'm long enough in the industry to remember all the files. I remember seeing a client who had 4 people in their HR department, very large company, and they just really went after holidays and they logged holidays, right? And they replied because they had a paper system. Crazy. Use a structured filing system by employee, department, or record type. Separate active versus archived, and limit access to authorized personnel only. Kind of straying into GDPR there as well, I suppose. So it's just really important if they're, you know, in somewhere like, I suppose, HRLocker that's firewalled, or if it's in the old system of your filing cabinet, you have it locked, etc., etc. Okay, so how long must I keep payroll records? As we said, 6 years. Next one is, do I need to keep a record for employees who leave? Yes. Retain for the recommended period right after employment ends. And can I keep a disciplinary records in someone's file even though it's expired? We get this a lot. Legally, once a disciplinary warning has expired, you generally should have not to keep it on the employee's active record for decision-making purposes. Keeping it could be seen as unfair or prejudicial if it's used later. That's a really good point. However, you can archive it separately, and this is what I referred to earlier, is having your archive file and your active file for reference if needed, but it shouldn't influence current HR decisions like promotions, pay reviews, or further disciplinary action. So you can't go back and say, geez, your man had a warning there for 6 months, a year ago. You can't use that as, a calculation for hiring or for promoting or whatever you're doing. And do I need to keep track of everyone's breaks? Yes, is the unfortunate answer to this. The contract entitlements alone aren't enough. You must record actual breaks and working hours to comply with the law and be able to show evidence if needed. And a clock in, clock out system is the easiest way to do it, rather than trying to record it. But it's not enough, believe it or not. Should the WRC come on site and they interview 3 employees and your employee says, oh yeah, we take even more break times than we get. The employer is really good. They're really flexible. You have to be able to show it. It's not enough. Even if 3 employees say, oh, it's amazing. You have to have a system and you have to be able to show where they've been offered and made available their statutory break times. What you're straying into here as well, if you don't do that, is rest periods, is really safety, health and welfare legislation. So you think about it, you have a guy working for you in a quarry and he's driving a machine. He works through his lunch because he wants to get home early. He has an accident. Now you're looking at rest periods. With the hauliers and that, you see this quite heavily regulated with tachographs and rest periods, etc. It's not dissimilar to just normal standard. You have to ensure that you have a good way of keeping those records. Okay, another little bit of a case example. And once again, as I said at the outset, anyone who wants more detail on this, we've no problem. So An employee filed a complaint against their employer for not receiving statutory rest periods and for working beyond the 48-hour weekly limit, as stipulated by the Organisational Working Time Act 1997. The employer failed to produce records of the employee's working hours. As a result, the burden of proof shifted to the employer, who could not provide evidence right to counter the employee's claims. The outcome, the WRC found in favour of the employee, awarding them $5,000 for the failure to provide a 24-hour rest period every 7 days and $5,000 for breaching the 48-hour working limit. The employer's inability to maintain accurate working time records significantly contributed to the ruling. So there's a lot in that little paragraph there. So 100%, it's really, really important that you adhere to the statutory break times, and the burden of the proof is really on the employer, as you know what, as Emer said. So it's critical that you have some kind of system, but make it as efficient and that it works for you, that you're not chasing paper all day. Okay, so takeaways there for the record keeping side of things. We'll just give you a few nuggets at the end of it. Legal compliance is mandatory. So I suppose you can refer to our sheet there of how long and which you keep. Retention periods vary. So when you only need to keep them for as long. Stay organized with structured filing and regular audits. And stay organized with structured filing and regular audits twice. Read the question. Emer was excellent on that. It's a double. She might have meant it, but I think it works quite well, Emer. Really, really important that we log that as well. I would certainly say this is the part of legislation that you will rely on, and it's really important your system is in place, that all of this falls under it. If it's not in writing, it doesn't exist, is really the way you should look at it. No matter what kind of a good relationship you have with the employee, it's really important that you cover it all off on that. Oh, and that's me. So look, a bit of a whistle stop towards the last one. I think we're in early. Right, as Crystel said there earlier, we'd be delighted if anyone has any queries, don't want to look at any documentation. You can just send them on, and Emer will come back to you on them.
And then I'm just going to finish up with
Great.
3 quick questions. Employees don't clock in and out for their breaks. And we
need to.
Right, they just need to.
Yeah.
If an employee's working time structure is logged in HRLocker, so I presume this is just in their settings and not the actual timesheet.
Yeah.
And their breaks are there, and we're telling them that they are being offered breaks. Is this enough?
No, you have to assure that they avail of them. It's not enough. Okay, so the contract of employment you can offer and make available. Break times have to be offered, made available, but you need to ensure that that's happening. How many times have we been asked, oh yeah, you know what, I'm going to work through lunch, I'm going to finish a half an hour early. Now, I know that can be sometimes. Look, I wouldn't have an issue with that as a one-off exceptional circumstance. If there's a hospital appointment or wedding, that's fine. But the general rule is offer made available and make sure they're taking them. And then kind of jumping on to the working time and the hours of work, it always comes into our office if someone's on hourly paid versus salary. So usually on our salary paid, we'll say your hours are X, Y, and Z. However, from time to time, you may be asked to, work extra hours, etc. But you can't make that consistent.
Yeah.
Whereas with somebody who's on an hourly paid role, it could be overtime or it could be an extra rate for Sundays. And then to throw it further into the mix, I know in the UK, they have an opt-out here. So that's not in Ireland. And this is a question we get a lot because we work with a lot of multi-site companies to say, can they have an opt-out? No, they can't in Ireland. It's rigidly adhered to.
Yeah, and actually it's something that we get all the time in
Really?
our timesheets, that they're like, well, can't we just submit it on behalf of the...
That's it.
No, you can't.
No, it's just for the headache of it. Have a system. What you will find is once you identify a system or you talk to people like HRLocker ourselves, and once that's put in place, it's just repeat. You just feed the machine.
Yeah.
You just keep going. It's the system that's a bit sporadic or you're really busy, and you need to get a contract out and you forgot a review. You're always going to be chasing your tail, but you'll find with a good system in place, you know what, it's part of your workflow.
Yeah, and then I'm not sure if the answer to this is, would a fleet management system record suffice? So I suppose it would depend what records come out of
it would. I'd have to see what the detail, is of that, like what comes out the other end, basically, and does it comply with the legislation requirements?
And then I'm going to finish on this because it's been asked 3 times is, does a contract need to be issued to a person doing work experience within the company? So TY, university, anything like that.
Okay, so there's certain rules for minors at work. Um, I probably well, that's a really good question. I've never been asked that before. So Emer, you might research that, will you? And get an answer. My initial feeling on it is yes, but we'll see what the consultancy team says. And then you're into, the age of the employee, and is it paid employment, and is it social hours, is it during holidays, is it during school? So there's a whole range of things you need to be aware of, but we'll come back to you on that one.
Perfect. And I know there's loads of other questions and we didn't get around to them, but I'm going to send all the questions.
Great.
Unfortunately, Emer's like, please don't send me on this question. And some really great questions. So I really appreciate your time today, both Terence and Emer. Like I said, we've worked with the guys for a number of years now, and I really recommend if you have any specific questions, reach out to the guys. And I would definitely say from me that they don't work on a fear-mongering perspective.
No,
It's about practicality and get your foundations in correctly. How do you make it that it's easy? And I think that a lot of the time, I always say this from a GDPR perspective and from a WRC perspective, is once you get your foundations in place, like the rest is should be
that's
easy.
it. That is the absolute key. You don't need a big, clunky HR department if you've only 10 staff, but you do need contracts, you do need a handbook, and a little bit of guidance to make sure you stay on the right side of it, and then you'll just fly.
Yeah, exactly. And then it's just rinse and repeat, like you
It is,
said.
of course, that's all it is.
So I'm going to send everybody's information out. If you want to contact Terence or Emer immediately, you can go to their LinkedIn or to the website. But probably towards tomorrow, we'll be sending out the recording, a list of all the questions and contact details as well. So thank you so much for your time, Terence and Emer. And thank you everybody for your questions. And sorry I didn't get around to all of them. We're just a bit tight on time. But Emer will be spending the next few hours answering the questions. Back to you.
I will.
Going for
Thanks,
lunch now.
everyone.
Yeah, exactly.
All right, thank you very much,
Thank you
guys.
very much.
Thanks to
See you.
everyone that
Take care.
attended. I really appreciate you taking time out of the day. And thanks to Crystel and HRLocker. Always a pleasure working with you guys. So yeah, so look, I hope everybody's a great day and a great week.
Yes, you too, guys. Bye bye. Take care.
Bye.